Now, viewers, the Karnataka High Court has imposed a fine of 5 lakh rupees on a father for allegedly quote-unquote abducting his minor daughter from the family court premises in Bengaluru. Now, the court directed the immediate restoration of the child's custody to the mother, observing that a quote-unquote child is not a commodity. Justice Chillakur Sumanathala has allowed the mother's plea, setting aside the family court's July 29th order that had earlier dismissed her application for custody. The father has been directed to produce the 7-year-old child before the family court today at 10:30 a.m. The court also clarified that he will not be allowed to conduct his case until proof of payment of the fine is submitted. I have my colleague, in fact, joining in soon to get us more details on this particular case, but a heavy fine has been slapped. In fact, I have my colleague for more on this. In fact, do tell us about the details of this particular case that have now come to the fore.
For the context, the petitioner mother had alleged that while she was present at a family court along with her daughter in July 2026, the respondent father abruptly took the child away in his car, and the child was taken to the residence of the father's sister, where the mother was allegedly denied entry. And according to the mother, police were duly informed and the personnel came to the spot shortly thereafter. However, according to the petitioner mother, the father along with their child came to the police station and took her away again without informing the police personnel. So the court, after hearing both the sides, highlighted that the father had not only violated the family court's interim order but also had violated the modified order passed by the High Court in a writ petition number 19158/2026 dated July 22nd, 2026. So the earlier High Court order in July had specifically permitted the father to take custody of the child for exercising his visitation rights from Pune and had directed him to hand the child back to the mother's custody at Pune after the end of the said term. So for further context, the petitioner mother had filed a petition seeking a dissolution of marriage by decree of divorce before the family court. Similarly, the respondent father had filed a plea before the family court seeking custody of the child. So out of the cost imposed, rupees 1 lakh shall be paid to the Army Welfare Fund. The court has directed, moreover, the remaining rupees 4 lakh should be deposited in a fixed deposit in any nationalized bank in the name of the minor daughter, is what the court had instructed further.
In fact, Belly, the court has in fact given out a very stringent statement saying that child is not a commodity. Do tell us about the detailed statement that has been put forward by the court.
The Karnataka High Court, after fining the father rupees 5 lakh for taking the daughter from the court premises in violation of the custody orders, also ruled that a child was not a commodity, and the court had imposed a fine of 5 lakhs on the father on abduction charges, and the single judge bench, Dr. Justice Chillakur Sumalata, allowed a plea preferred by the petitioner mother while setting aside the Bengaluru family court order dated July 29, 26, which had dismissed her application seeking production and restoration of custody of her minor daughter aged around 7 years. So while allowing the plea, the court has instructed the respondent father to produce the child before the family court on August 25, 2026 at 10:30 a.m. for handing over the daughter's custody to the mother. So the court has also clarified that the father would not be permitted to conduct the case in the family court until proof of payment of rupees 5 lakh cost is produced, Hina.
All right, thank you so much, Belly, for all of this. Now, shifting our focus to more breaking news coming in.